The city fined a third-generation farmer $50,000 for a pond his grandfather built in 1952. New neighbors needed more water. But watch the moment the judge checks the priority date.
My grandfather built that pond in 1952. My father used it. I use it. 2 years. Then 5 years ago, a development went up 3 miles away, Cottonhane, 800 homes, 400 wells. Now the city says my pond is an unauthorized diversion. I'm the third generation on this land. That pond was here before most of those homeowners were born.
Our hydrologist report confirms the pond intercepts approximately 4.8 acre-feet annually from the watershed. In an over-appropriated basin, undecreed diversions cannot continue regardless of historical use. The $50,000 fine reflects the severity of the ongoing violation.
I see 400 wells that lowered the water table by 40 feet. I see 400 acres of pavement that stopped natural groundwater recharge. And yet your expert claims the problem is a pond that hasn't changed since Eisenhower was president. That is not how water law works. This pond existed 70 years before the development was built. Priority date, 1952. Prescriptive water rights confirmed. The $50,000 fine is dismissed, and the city will pay $180,000 for 3 years of unlawful prosecution.
Gardening with accuracy is suspicious?
A homeowner received an official warning from his HOA. They claimed his activity was unusual and needed investigation, but when the reason was explained in court, even the judge couldn't believe it.
Your Honor, I was simply gardening in my own yard when I received this warning.
I was planting, watering, and arranging my plants like I always do. There was nothing unusual about what I was doing at all. I don't understand how basic gardening became a violation. Your Honor, the activity appeared unusual and raised concerns within the community. The pattern and behavior observed did not appear typical. This led to a precautionary notice being issued.
We believed further review was necessary.
What exactly made this gardening activity suspicious?
Be specific about the concern.
He was measuring plant spacing with a ruler repeatedly.
You're saying gardening with accuracy is suspicious? This is not a violation. This is just gardening.
Like and subscribe for more courtroom stories.
A retired iron worker secretly reinforced his 79-year-old mother's mailbox post with a solid steel pipe after drunk drivers kept destroying it and speeding through her front yard. When a street racer hit it at 60 miles per hour, the car crumpled. The driver's family sued the old man for $75,000. Watch the judge's reaction.
Your Honor, the defendant deliberately concealed a solid steel pipe inside what appeared to be a standard residential mailbox post, directly on the public curb line. He created a hidden fixed hazard and disclosed it to nobody. The vehicle sustained $75,000 in damages on contact. This was not a mailbox, it was a trap. We demand full restitution.
Your Honor, I spent 34 years as an iron worker. In the last 2 years alone, 3 different cars jumped that curb and destroyed my mother's mailbox. One went through her front yard and stopped 12 feet from her bedroom window. She stopped sleeping through the night. I built a proper post on her private property. This holds her mail just fine. Was I supposed to wait for the next car to come through her living room wall?
Your client was doing 60 miles per hour on a residential street at midnight and destroyed his car in a mailbox, and you brought that in front of my court? This man built a sturdy post on private property to protect his elderly mother from the exact situation your client created. Dismissed with prejudice. Your client owes him $50,000 for property destruction, legal fees, and 2 years of his mother's sleep. Case closed.
He spent 15 years breeding champion koi fish worth $90,000. The city bulldozed his pond while he was at work because he didn't have a wetland permit. All 200 fish died in minutes.
I've been breeding koi for 15 years. Some of those fish were worth $2,000 each. Champion bloodlines. They bulldozed my pond and buried everything. 200 fish died. I got a notice saying I needed a wetland permit. I called the city to ask about the process. They said they'd send information. A week later, bulldozers showed up while I was at work. My neighbor called me crying. By the time I got home, my pond was filled with dirt. The fish were buried alive. 15 years of work, gone in an hour.
Mr. Nakamura's pond exceeded 500 square feet, which classifies it as a man-made wetland under city code. He never applied for the required permits despite multiple notices. We sent 3 notices over 2 months. He had time to comply. When he didn't, we exercised our authority to remediate unpermitted structures.
Ms. Henderson, you bulldozed the man's pond full of living creatures without giving him time to remove them? You killed 200 fish?
The notices instructed him to obtain permits or remove the structure, Your Honor.
The notices didn't say you were going to show up and bury living animals alive. He called asking for information and you sent bulldozers instead of permit applications. You destroyed $90,000 worth of champion koi fish because of a permit dispute. That's not code enforcement. That's destruction of property and animal cruelty. I'm awarding Mr. Nakamura $90,000 for the fish, plus $50,000 in punitive damages. The city will also pay for pond restoration. This was unconscionable and cruel.
They generate their own power and treat their own waste. The city is suing them because they refuse to pay for their water and their electricity. They call it a code violation. He calls it freedom. Watch the judge weigh in.
Your Honor, so I have a certified lab report that shows our water is cleaner than the city's water. My septic is engineer stamped. We aren't being fined because we're unsafe. We're being fined because we won't pay the $30,000 hookup fee for services we don't want nor need.
Your Honor, under County Ordinance 17.04, any dwelling located within 300 feet of a municipal line must connect to the public utility. Private waste systems in residential zones are a public health risk, and without a grid connection, we cannot issue a certificate of occupancy.
Yes, and Counselor, the codes are for safety, okay, not revenue. This report proves their system meets, well, actually exceeds state standards. You can't force them to buy into the system. The condemnation order is vacated. Leave these people alone. Thank you.
He used a $5 tool to turn on the heated seats he already paid for. A billion-dollar company sued him for $100,000 for technical theft. But watch the moment the judge finds the company's illegal firmware update.
He hijacked a revenue stream belonging to our shareholders. Bypassing our security gate is theft of intellectual property. Modern vehicles are a service. If the subscription ends, the feature stops. It's a clear breach of our digital ecosystem.
I paid $150,000 for this car. When they tried to charge me $20 a month for seats I already owned, I just used a $5 tool to bypass their software lock. I just wanted to use the features that I paid for.
Mr. Brooks, when a customer buys a car, they own the wires too. Your illegal firmware update was remotely disabling safety systems just to extort monthly fees. Mr. Springer exposed a felony fraud, order for restitution issued, case dismissed.